I'm sorry, I don't know what it's doing. Like redacting it.
You said it's redacting?
That's strange.
Yeah.
Let me know when you're ready.
I'm glad I caught that, but sorry I had to interrupt.
I'd say it was funny, but since it's happening right now and not at a different time, it's not very funny. You guys want to come head up to the table?
I'm just gonna try it with the new file. It looks like it's working.
Is it ready? Okay. All right, this is docket 25-5017 CK, Lori Leroy versus Chager Properties. Counsel, your appearances for the record. And ma'am, you are not an attorney, is that correct?
That is correct.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. Put your hand down in counsel.
Good afternoon, Your Honor. Tim Washburn appearing on behalf of defendant Charger Properties. The full defendant was not listed as Charger Holdings Incorporated is the actual party with the DBA or assumed name of Charger Properties.
Okay, sorry.
No, you're okay. Your Honor.
I couldn't read quite the name, so I thank you. All right. And this is defendant's motion for summary disposition pursuant to Michigan Court Rule 2.116C8. Maybe we have a seat. Counsel, you may proceed.
Do you want me to podium, Your Honor, or is it
Please.
fine? Good afternoon, Your Honor. We're here today for our motion for summary disposition. What this matter involves is a complaint of uncertain nature against my client. I was going to provide an answer, but frankly, it doesn't comply even enough with the court rules for me to do that. I don't really fully understand the complaint, nor do I understand the damages. In lieu of
Counsel, I'm going to stop you there. I do understand the complaint there. She's alleging a breach of contract, the habitability. She claims the dwelling is uninhabitable, and it's uninhabitable as a dwelling place. It has bed bugs, cockroaches, feces in the hallways in the apartment building, and she gave us the location. So the claims are a different issue, but in terms of what she's asking for, but I think it's really under the warranty of habitability, and she's been specific as to what it is. So let's take it from there.
I'm happy to focus on that, Your Honor.
Thank you.
So for example, on February 26, 2025, a landlord-tenant matter was filed against the plaintiff. She appeared, there was a judgment entered, they worked it out. She chose to stay. She could have brought up all these claims at that time. She could have presented evidence at that time. She was in court.
Was that in district court?
Yes, ma'am.
And who was it that in front of?
I'm sorry?
Do you know which court?
Yeah, if I can check real quick. It was 54A, and that was matter 2025-25-01353-LT.
Okay.
I believe, the best of my belief, it was stemming from some unpaid utility charges. Doesn't really
Oh, I
matter.
interrupt.
No, because if you do, I'll hold you in contempt.
Okay,
You
well,
don't have your-
I tell my story, I tell my side after he's through because.
Ma'am, yes, and if you say anything else, I'm gonna toss
Thank
this
you.
case. I'm not sure it should be in front of me anyways, but if you wanna be rude, I get it. I'm
Oh,
gonna
no,
get a
I
deputy.
apologize.
I'm gonna get a deputy here now. If you say anything else, I'll hold you in contempt and we'll house you for 93 days in the jail.
I'm sorry.
Thank you. I need a deputy. You may proceed uninterrupted, counsel. Sorry.
Thank you, Your Honor. As I was saying, I don't know the exact just the matter, doesn't really matter. It was
I'm
the
sorry.
matter.
I don't, as I was saying, I don't know the exact what.
Just of the matter.
Okay.
The
And I
subject-
just need you to slow down a little bit.
I'm sorry, the subject matter of that landlord tenant case. However, the party was served, had a chance to appear, could have brought, and in my opinion, should have brought any of these inhabitability positions at that time. That's not what happened. Contrary to that, that matter, whatever the money judgment was paid. She stayed in the apartment throughout not only the term of the lease, but beyond the term of the lease. So June 2nd is the date that I have been provided by my client, is the date she actually vacated, that they received keys and the vacation was completed. What happened subsequent to that was there was some damage to the unit, and so they sent a notice, and that was ignored, not responsive by the guarantor or the plaintiff. And then it's been just kind of kicking around in collections, and I don't know exactly the state of that matter, but then all of the sudden, this was brought to our attention. So I just think when you look at the context of what's going on, the fact that she could have appeared, I'm ignoring all the court stuff at your request, Your Honor. Obviously, yeah, there's opinions on some of those, but I understand it. The fact that she stayed through the lease term, I'll keep it very brief. The fact that she could have argued any of these matters.
Okay, she could have what?
Argued any of these matters at the landlord-tenant hearing. And now it's being brought up in circuit court, which I would argue is not the proper venue for this regardless. The damages are at best uncertain, and certainly undefined. I can't imagine they've established that they can exceed $25,000, Your Honor. So.
I think the request is 50,000.
Correct, but there's no basis or there's nothing provided.
I understand what you mean.
Yeah, and Your Honor, just to get to the point of the rules, I mean, we're not trying to play games, Your Honor. We named the proper defendant in our reply. I attached what I believe is the least that the plaintiff was arguing that was not attached to the complaint. We're not trying to play games. We're just trying to be clear and understand what we're defending and what the answer. If I have to file an answer, Your Honor, I will. But I just don't think this is a proper venue, nor do I think that I don't think it's a legitimate claim, but she stated an actual claim under the court rules that can be awarded. So respectfully, Your Honor, keeping it brief in the name of brevity and just getting this matter, to decision, we respect that summary decisions entered and the case is dismissed.
Thank you. Now, ma'am, you may approach the podium and respond.
Thank you, Your Honor. I do apologize for that. So on February 26th, I filed in this circuit court. Prior to that, I did go to the civil and 54A, and being that the costs that were endured, and along with any other violation that was placed against me as a tenant, I hereby would like to admit to the court that I was contacted, and with the letter of answer from Charter Properties, DBA, after filing, they answered in a direct manner that they're not taking responsibility. Therefore, it should be refiled against the proper defendant, which is Capital Manor Apartments. With that said, I guess if I could refile against the proper defendant.
Ma'am, I don't think you're even in the proper court.
Well, I was told that if the costs were endured in violation, that
Tell me about your
all the
costs.
lost property damages that incurred over 25,000, that this is the court to do so. 54A stated that to me.
Okay.
Yeah.
I got that. Tell me, you have not, this is the fairest complaint I've received in my 20+ years on the bench. I know you're not a lawyer, but what you're suing for is pain, suffering, anguish, court fees, $50,000. It doesn't say anything about property or what. You have to plead with specificity, and
Right, and go ahead, Your Honor, sorry.
And I don't know how this rises to the level of $25,000. It also seems that this is something that should be in district court. So tell me why we're here and how you're going to get to $25,000 plus.
For the fact of I had to resubmit, and if so, I guess I could amend it if allowed by the court, Your Honor. I also have an added, violation, liability, of the tenant, of the landlord, who is apparently not in charge of properties, but I can move on with that later and refile against the proper, defendant. However, I have amended and overlooking over all the violations, starting with landlord tenant law, which is, there's a Michigan implied law, a warranty. For that said, there's premises
Wait a
liability.
minute. Which there is a Michigan implied law, a warranty
Yeah, a warranty of habitability
of liability.
in the state of
The
Michigan. yes, ma'am.
warrant, it's the warranty of habitability is what she's referring to. Ma'am, you had a district court case, a landlord case, where that should have all been handled because there could have been an offset to whatever rent they claimed you owed them or damages. And why didn't you bring that then? This is not, I'm not landlord tenant.
Why would I bring that then?
Why
Because-
didn't you
Because the
bring it?
landlord,
Wait
continuously.
a
Stop, ma'am, you cannot interrupt me,
Oh, sorry.
okay? Where would you like us to pick up, Nancy?
There could have been an offset where they claimed whatever rent you owed or damages. Why didn't you bring that then?
For the fact that you mean in court or to the landlord themselves?
In court, when you had the dispute with the landlord, this.
I never had a dispute with the landlord, ma'am.
You were,
It was unpaid, money owed, and we settled that. Had 2 weeks to pay, and I did so.
that's a dispute with the landlord. One of the offsets for non-payment would have been to put the money in an account, claim they broke the warranty of habitability
Because I didn't,
by having bed bugs, cockroaches, feces in the hallway, etc., and you didn't do that then. And now you want me to resolve something.
because I had to, yeah, well, for the fact that when I went to court, the LT, that was under the, money owed, and, I didn't know how to handle the case at that time. They would not let me out of my lease, to begin with. They ignored me. The manager of the apartments contacted her lead supervisor, and which is through HR, which is through charge of properties. They ignored me, and I was pretty much forced to live there. I had from the beginning asked to be let out of my lease due to uninhabitability, due to getting bedbugs bites, due to a lot more things, Your Honor.
Okay,
Yeah.
ma'am, if you asked for all of that, then that should have been dealt with in the district court case. And my understanding, is it true you were a holdover? You stayed there after the lease ended?
No, I gave them 30 days notice, it's in writing. I signed it in the office with Andrea Presas,
So
who's
you,
currently, the manager is in the office.
so the lease ended and you extended it despite bed bugs and.
No, I never extended it. I gave my notice. I would extend something that I'm being violated and scarred from. Absolutely not.
Okay, let me just stop you there. Counsel, did she extend or was she a holdover?
I believe there was a notice that she was gonna terminate on the end of the lease term. However, she did not actually vacate, so it's a possession issue. It's not about, she was actually a holdover at the time for 2 days. June 2nd, I think the 30th was the date she was supposed to at the end of the lease term, I think.
Okay,
Yeah,
Okay.
May 30th was the lease term, Your Honor. She left on June.
On the weekend,
so.
which was allowed me from Andrea Presas, the
Which
manager in the
which
office.
is what? On the weekend,
Yeah, I was moving out of the weekend, on that weekend, and Andrea Presas, who's the manager in the office, said, by Monday, as long as you have the keys turned in our box, by the time I get to work and the office is open, you're fine. You can take.
Okay, got it. I'm done with that.
Thank you.
Okay, so now what? How are you gonna get to $25,000?
With premises liability due in the fact of damages, personal injury.
What's the damages?
The damages, do I have to present all that today?
You must
Because I
know
have,
them.
because I have proof of evidence that I would need to gather the rest of.
Ma'am, I'm asking you for what we call in the law an offer of proof as to why I should keep this case alive. So you tell me what you know.
Okay, for personal injury,
What's the personal injury? Do you have doctor's statements?
I do.
What's the personal injury?
The personal injury that I was forced to get bit up, throw my groceries away every month. My cat, suffered, a lot. My cat almost lost her life in it. She lost all of her hair. We had to take her out. We had to move continuously out everything and belongings in our kitchen. Several times, there was twice in 1 week, there was pest control, administered in our apartment. Also, I had bronchitis during this time. I had to go to ER. Yeah, there's medical documentation plenty. There's also a specific, I have credible, people in this city, including English County Health Department, 2 employees, one from the Code of Compliance of City of Lansing and one from the Health Department of City of Lansing.
So do you have actual receipts that say that out of pocket you paid more than $25,000?
No, because they were, pretty much heirlooms handed down to me by my mother. Her couches given to me, there were bed bugs infested all over it, as well as my bed had to be thrown out down in their dumpster. I have scars on my back from the bites. I was getting, I can go into detail of what happened physically, injury to myself, mentally, socially, and sleeping on the floor and still getting bit by bed bugs every night.
And you said that they treated those bed bugs, is that correct?
They treated, but they were still there, ma'am. It's within the walls. The whole thing should have been demolished, and that is why I contacted City of Lansing Code Compliance, and his name is David Huck.
And what was the response from them?
He served them with an inspection throughout the whole building,
And
and it still continued.
did he find that they were not in violation?
I don't know about that because I was not reached out to, but I could certainly find out.
Anything else you want me to know?
That I definitely want to include and induct into this claim.
I definitely want to include what?
I definitely want to serve proof of evidence towards the court and proof of credible witnesses in this whole county, including my physician provider, Maria Sagan.
What's the last name?
Sagan.
So do you have, again, evidence that this case, if I keep it alive, is over $25,000?
I do,
I don't see it.
because of pain and suffering, my injuries that I may be suffering for some scar tissue. I visited, I've been under the care of my doctor, I've been under the care of a specialist who works for DHS. She literally walked into their office and told them, when are you gonna do something about these bed bugs? So I'm sure I can, and with your credibility, Your Honor, if you feel that it's under 50, I mean, if you feel that it's more than 25,000, then I don't know, I just have to go, I just have to go with that right now. I'm not gonna give my answer.
I don't know what it's worth. I don't know if it's worth 5 cents or $50,000 or.
Well, I do.
Well, you don't know, man, because you've been all over the place. I don't have any evidence here, and you've pled very little here. So
Well, I didn't know that this was, the day when I'm supposed to show proof of evidence, but I sure have it, and I can supply it within 24 hours.
Well, man, they've asked that this be dismissed because you haven't followed the rules of specificity. They don't know what you're asking for. I'm still unclear.
Well, I'm still.
If you interrupt me again,
I'm
I'm
sorry.
going into holding. I am not kidding. I've got the officer here. Sir,
I
if she
apologize.
interrupts me again, I want you to just launch her right into holding until she calms down. I'm not gonna continue like this. It's disrespectful. I'm trying to figure this out. I
Okay.
don't have to. I could dismiss this in
I'm
10
sorry.
seconds. You did not comply with the law, the court rules, or anything that I can see. I don't know why I should keep this alive. Have a seat. Counsel, please respond.
Thank you, Your Honor. Just to summarize, the issue of the habitability should have been dealt with through landlord tenant matter. If cost was an issue, the landlord paid for the proceedings. She showed up for free. She could have argued whatever she wanted to
Okay,
argue,
you need to slow down.
argue for free.
Hold on. If cost was an issue,
She could have shown up and argued her position for free. There was no cost to her to appear in the landlord tenant matter. Not only was her landlord tenant matter, then she had to pay over, I think it was over $1,000, which she paid to remain in the unit that she says was so dangerous and so painful to her. I've been with this client for decades. It's somebody that I know, I represent them. This is not, obviously each property has a different entity that owns it, but this is somebody that I've known for literally over 25 years. Bed bugs are an issue. They deal with them. Tenants hoard things, they keep food, they sneak pets in. It's an issue that unfortunately that this client has to deal with across the state. They don't think it's a joke. They don't think it's funny. They take it extremely seriously. They spend tens of thousands of dollars a year to fight bed bugs that are brought to them at no fault of their own. When a bed bug complaint is made, someone goes and inspects. However, if there's no droppings, if there's no evidence from it, then they would do nothing. And frankly, that's reasonable. This is not someone who's unfamiliar with such matters. This is not someone who ignores such matters. Bed bugs, if they let them go, could cost them hundreds of thousands of dollars, could close an entire building. This is not something that they think is funny or would mess with. This is something they get after right away. They have a team of professionals that get brought in. Their staff is trained what they look like and what to look for. They're all very familiar with this matter. I spent a great deal of time on this file because I didn't understand. I wanted to make sure I understood if there was something here we wanted to present properly. We're not trying to be anything other than represent ourselves in a fair manner, Your Honor. I didn't find any inspection report, not that it doesn't exist, but I didn't find it in the file. Typically would have been in the file. I didn't find any evidence of anything other than pictures of damages that which I attached to the motion. I have color copies of today. The thing is too, Your Honor, I mean, and this is somewhat irrelevant, I want to hear to you, but 14 cases in 54A, 3 of them landlord tenant for the same.
3 of
party.
them what?
Landlord tenant for the same party. 1 case in 55 district court, landlord tenant. This is someone who understands the legal system, and I understand they're not a lawyer, Your Honor, but they've been to court as more than a lot of people. They understand this process. They understand how to go to court. The defendant, despite all of this, has tried multiple times, even after the complaint was filed, to try to reach this party to say, hey, what is going on? How do we work this out? They don't want to pay me to be here, Your Honor. They don't want to defend this case. They want to settle it. And if something happened, they want to work it out. But everything I've found, Your Honor, everything I've seen, Your Honor, doesn't show anything other than someone who uses the legal system to try to maybe not pay some kind of damages owed. And that's all I have to say, Your Honor. Thank you.
Anything else, ma'am?
Do you want me to approach, ma'am?
Yes, please.
Thank you, Your Honor. Yes, ma'am. Thank you, Your Honor. I do want to get this in order and get my best ability. Due to the fact that if I didn't know that at that time, I would have brought it up. I wanted to leave in good standing with no money owed, so that I could get in, hopefully, not get denied at my next place that I would be applying at to live. Because when there's unpaid dues, obviously we all know that it affects your ability of getting approved at your next living, apartment, dwelling, duplex, wherever. Due to the credibility, your credit, everything won't work out fine. So that is the reason why I wanted to pay that off. With that said, with any other damages that are due at this time, I never declined, I never denied them. They are going to be dealt with, and I am doing so to definitely pay that. There'll be arrangements made. I have spoke to that third party. There's no way that I would disregard money owed, especially if I'm responsible. So I just wanted to answer that part. Also, the fact that, I very much so intend and have well intentions of carrying through with this, to the damages and injury and social, everything else that, continues to bother me to today, has affected my life, has affected me with, my weight loss, with, you know, with a lot of traumatization that has been left in me, Your Honor,
There's a lot of traumatization, what?
that has affected me and it impacted my life at this time. Which I like to include my livelihood, my eating habits, my sudden weight loss. Um, It's impacted me tremendously. I had to throw that everything that I own. My mother, I couldn't go visit my mother. My mother has a very nice place, I'm sure you all do too, but this is,
Wait, I couldn't go visit my mother what?
my mother's 86, almost 87.
His what?
I'm 86, almost 87.
Oh, okay.
There's only one power of attorney and capable beside myself. There's a sign, which is my sister. I was the only second one to take care of my mother, who lives way out of town. She gave me that couch. She purchased that many years ago from Pilgrim House. She did not even want to give it to me, but being that I didn't have furniture, I begged her to, only to get infested up. To this day, right now, my mother does not know what is frantically happened. That has affected my life. The furniture being thrown out, nor the time that I had to give up of visiting and taking care of her, because I didn't want the bed bugs to go to my mother's house next. The comfortability of relaxing in my mother's house even. It's not the same, especially when I'm still living there, afraid that I'm gonna get anything in her house. It would affect that. And her not knowing about the furniture.
Do you have a new place to live, ma'am?
I do know,
Okay, and are there bed bugs in there?
no ma'am.
Okay, great. So here's what I'm going to do. I am finding that your complaint fails to meet the requirements in the court rule, because your complaint, although is understandable, is not clear, concise, and direct and specific. You need to plead with specificity in Michigan because there is a notice requirement. It does not contain the specific allegations necessary to reasonably inform defendant of the nature of the claims. While I know what areas they are in, they are not specific enough as to outline the various damages you indicated today, as well as specific enough for defendant to respond to them with what they did or did not do, etc. Furthermore, you claim to have medical issues, but there are not medical issues specified here. It says pain, suffering, anguish, and court fees. There's nothing here about bed bugs, long-term scars, any of that. Ma'am, don't interrupt me. You may be able to get that, but that is not the law. You did not comply with the specificity needed to keep this case alive. Therefore, for those reasons, the non-compliance of the format, the specificity, the notice, and granting the motion for summary disposition, and also based on 2.116C8. And ma'am, if you want to correct it, you may refile. However, I suggest you think long and hard about coming into this court. It sounds to me, and I'm not your lawyer, I haven't seen your evidence because I am very unclear about everything. This may very well be a case for district court. I don't know that it rises to the level of circuit court, but maybe we'll figure out more if you plead with specificity. You certainly can get some legal help through the State Bar of Michigan, landlord tenant. There's different landlord tenant resources. There's a landlord tenant resource center. There are places where you can get legal assistance. You can properly file and have your case heard. I'm a big believer in listening to people in court and having your case heard. But ma'am, here today, you have not complied with specificity, you've not complied with the court rules, so I cannot lawfully keep this case alive. It is dismissed. Thank you.
Thank you. Your Honor, I appreciate your patience and at least, and I do appreciate the one that you stated, that the impact of listening to the, to their story at least, and you did that, and you also gave me whatever advice that you could in your law, in your courtroom, and I wanna state this, that I thank you very much for that, and you have a
Thank
wonderful
you.
day,
So-
thank you, Your Honor.
I don't know, Brian, if do we have a list of places she can contact for help?
I don't have a list of housing places now.
Not housing, I mean, for legal assistance.
Just Michigan Legal Help is the only one that and Michigan State's housing clinic.
There's Michigan State's Housing Clinic. There's also the State Bar of Michigan has, you can get an attorney. Every attorney is supposed to donate some time, so I would consult with an attorney, ma'am. before
I
you-
appreciate that, I really will, Your Honor.
And I don't know how old you are, but there's also the Elder Law Clinic that can help. There are enough clinics that can
I
help you.
know, I appreciate that so much, I've been looking into that and MSU and all of that nature, I'm not giving up, so, I just don't want the next person to be a victim, Your Honor.
Well-
Thank you.
All right, but you've got to have some specific damages, and if I were you, I'd spend some time with your mother. You don't have any bed bugs anymore, go see your mother.
I am,
Okay.
oh, I definitely am.
Okay,
They even
well,
got in our vehicle.
I think that will help you greatly. Good
Thank
luck
you,
to
Your Honor.
ma'am.
God bless you. Thank you so very much.
Thank you, Your Honor. I'll submit the order via mail if that's okay.
Thank you.
Okay, thank you again. Appreciate it.
3463NM SRHS LLC versus Eastside Tax and Accounting LLC, Tom Johnson and Joyce Bonet. Counsel, your appearance for the record.
Good afternoon, Your Honor. Peter Brown on behalf of the plaintiff.
Good morning, Your Honor. Sophia Sunderhaus on behalf of the defendants.
All right, thank you. And this is defendant's motion.
Yes, Your
for
Honor.
Motion for summary disposition based on C8. You may proceed.
Thank you, Your Honor. May it please the court.
At the podium, please.
I'm sorry.
At the podium, please, if you would.
Oh,
mind.
yes, of course, Your
Thank
Honor.
you.
Thank you. May it please the court. We're here today on defendant's motion. We rely on our arguments and legal analysis in our motion and reply brief, but we'll briefly summarize and bring to the court's attention several key arguments. Defendant's motion for summary disposition comes before the court under MCR 2.116C8.
And you need to slow down, please.
116C8.
Absolutely, I'll slow down. Thank you. Under 2.116C8 and is based on deficiencies in plaintiff's complaint as it does not state claims upon which relief can be granted, lacks specific factual allegations as required by MCR 2.111B1, fails the particularity mandated of MCR 2.111B1 for fraud, and does not comply with MCR 2.113C1 for its contracts claims. Accordingly, defendants ask the court to dismiss plaintiff's claims or order plaintiff to amend their complaint.
Okay, you have to slow down. It's been a long day.
Of course, I'm sorry.
Accordingly, defendants ask the court to dismiss plaintiff's claims or
Order plaintiff to amend their complaint to comply with the Michigan court rules. First, plaintiff's complaint as a whole is deficient under MCR 2.111B1. The complaint relies on conclusory recitations, failed to timely file Form 2553, failed to provide accurate bookkeeping, failed to report and pay taxes. These are quotes directly from plaintiff's complaint. Without the who, what, when, where, and how necessary to reasonably inform defendants of the claims. This mirrors what Michigan courts disallow. Tracking elements without underlying facts warrants dismissal. Second, plaintiff's claims of fraud lack particularity under MCR 2.112B1. The fraud count does not identify the speaker, the time and place, the content of the misrepresentation, or how it was false. Instead, it pleads collectively defendants and generic topics of services and invoices. Accordingly, count 2, fraud misrepresentation, must be dismissed for failure to satisfy MCR 2.112B1. Plaintiff's MCPA, Michigan Consumer Protection Act count, simply repackages the same vague fraud allegations and therefore fails for the same reasons. Additionally, the MCPA claim does not apply to commercial services rendered to a business. Plaintiff itself frames these as tax accounting, bookkeeping, and payroll services for a restaurant business. Accordingly, the MCPA claim must be dismissed, as does the fraud claim. Third, plaintiff's breach of contract claims fail to comply with MCR 2.113C1, and the complaint lacks the essential terms of a contract. Plaintiff alleges a contract but attaches no written instrument and pleads no exception in the complaint, which alone warrants dismissal. It also fails to plead the essential terms, counterparties, or what provisions were breached. The complaint also illogically alleges a single contract with a company plus 2 individuals in their personal capacities, which would be highly irregular. Accordingly, plaintiff's breach of contract claim must be dismissed under MCR 2.113C1. Fourth, plaintiff's malpractice or professional negligence claim must also be dismissed as it fails to include essential facts to establish duty, the scope of the negligence and duty, and the breach. The negligence allegations mirror the contract allegations and remain conclusory. No dates, no standard of care particulars, no identification of which defendant did what or when, and no facts tying any alleged act to any damages. Accordingly, plaintiff's malpractice and professional negligence claim must be dismissed under MCR 2.116C8 for failure to plead underlying facts establishing duty, scope, breach, causation, and damages beyond conclusory phrases. Finally, as plaintiff's claims have failed, so do its respondent superior or vicarious liability
Okay, I'm
claim.
sorry, so do its respondents what?
Respondent superior. Yeah. And vicarious liability claim because there is no sufficiently pled underlying tort to support the claim. Without adequately pleading an underlying tort with particularity and factual substance, the vicarious liability count cannot stand. In response to our motion, plaintiff filed a reply which still does not cure the defects of plaintiff's complaint. Therein, plaintiff improperly relies on an email, Exhibit 1, which is outside of the pleadings, and on a C8 motion, the court considers only the pleadings. Plaintiff concedes the standard in its own brief. Even if considered, the email is not an admission of fraud or actionable wrongdoing. In conclusion, plaintiff's complaint fails under MCR 2.11B1, 2.112B1, and 2.113C1. And no amount of generous notice pleading dispenses. No amount of generous notice pleading dispenses with the requirement to plead underlying facts and fraud with particularity. Accordingly, we respectfully request dismissal with prejudice of all claims and denial of plaintiff's request of fees. And Your Honor, we understand that the recourse here is likely that plaintiff needs to amend their complaint and to provide additional facts so that defendants can properly respond to the claims therein. We understand if the court is not willing to completely dismiss this complaint, and we understand if that is the solution here today. Thank you, Your Honor.
Need a response?
Good afternoon, Your Honor. Peter Brown on behalf of the plaintiff. Your Honor, this motion is frustrating for the plaintiff. I've looked at my complaint since receiving this motion several times, and it's a well-pled complaint with specific factual allegations. The plaintiff operated a restaurant known as Capo's Cheesesteak and Hoagies and Grill on Grand River Avenue in East Lansing. Defendants, of course, defendant Eastside Tax and Accounting is an accounting firm. Our allegations in the complaint is that Mr. Tom Johnson is the owner and Ms. Bone participated in rendering accounting, bookkeeping, and payroll services for the plaintiff. It's a standard professional malpractice complaint that also includes fraud and breach of contract in addition to some other complaints. The allegations are very clear and they meet Michigan's liberal pleading requirements. The complaint alleges that between 2021 and 2024, defendants represented to plaintiff that they were performing accounting and bookkeeping services for plaintiff. Defendants invoiced the plaintiffs for those services. However, the defendants didn't actually perform the services that they were representing to the plaintiff that they were performing. It's outlined in our complaint what those services were, and I will recite these three items to the court. First, the defendants failed to file an IRS form 2553S election. They failed to timely file that, despite representing to the plaintiff they filed that and invoicing the plaintiffs for that. Number two, they failed to provide accurate bookkeeping and maintain defendants' financial records during those 3 years, causing the financial records and the tax returns for the plaintiff to be incorrect. And outrageously, the defendants failed to report and pay the plaintiff's sales, withholding, and unemployment taxes. They represented they were doing these things for 3 years, and it turns out in 2024, the plaintiff found out that these things weren't actually happening. I don't know how much more specific I can be, or how much more specific I'm required to be under the court rules. These factual allegations in the complaint are unmistakably clear. Defendants falsely assured the plaintiffs that accounting and bookkeeping services were being performed when in reality they were not. Despite this deception, the defendants billed the plaintiffs for these non-existent services, and plaintiff, relying on defendants' representations, paid defendants for these services. Plaintiff has been substantially damaged by the negligence, fraud, and breaches by the defendants. So when the defendants now claim that there was no who, when, where, what, and why, I disagree. I
was just gonna say, in terms of the invoices that you're complaining or believe were fraudulent, did you specify which ones, or are they all fraudulent? It looks to me like you do have some specific ones, but you're requesting all of them. Are they all fraudulent?
We don't know, and I think that's what discovery needs to find out. We don't have all the invoices in our possession, custody, or control. We know, though, that certain items that were billed for were not actually done, and specifically, that's the reporting and payment of plaintiff sales, withholding unemployment taxes. And so discovery is going to provide the parties with some ability to do an investigation. Experts are going to get involved. But with respect to the pleading requirements, we follow the elements of the claims. When they talk about who, when, where, what, and why, it's obvious who. The plaintiff was the customer, the defendants were performing accounting and bookkeeping services for the plaintiffs. The when, between 2021, when the defendants were engaged to provide these services, and 2024, when the representation terminated. Where? This occurred in Ingham County. What? The defendants were engaged to perform tax accounting, bookkeeping, and payroll services for the plaintiff. Defendants represented that those services were being performed. They were invoiced, they were paid, and then we found out that those services were not actually performed. The why? That's a good question, and that's what we're going to find out. Why did the defendants do this to the plaintiff? Why were they representing that they were performing these services, but these services weren't actually being done?
And do you have a contract, and one is supposed to be attached, or was it a verbal contract?
We allege a verbal contract, Your Honor. We just, and in the complaint, we allege that there was a contract. We don't allege that there was a written contract. Pursuant to this court rule cited by the defendants, MCR 2.113C1, that requires an instrument to be attached to a complaint when a claim is based on a written instrument. There's no allegation in the complaint that there was a written instrument. In response to the motion, we have said that we don't believe there was a retainer agreement signed by the parties in 2021 when we engaged the defendants. That doesn't mean there's not a contract. That doesn't mean that defendants didn't decide that they were going to engage and do these accounting and bookkeeping services for the plaintiffs. That just means we don't know whether there's a retainer agreement signed. To the extent there was one signed, it's not in the plaintiff's possession, custody, or control. It may be in the defendant's custody or control. We're going to find that out during discovery, but that's not a fatal to a breach of contract claim when we allege. And I don't know how much Your Honor would like me to get into the complaint, but my response tracks the complaint. And in paragraph 35 of the complaint, we allege plaintiff and defendants entered into a contract wherein the defendants agreed to, and I lay out what they agreed to do. And if that is proven to be true, then we have stated a prima facie case for breach of contract. It goes on to state that there is a breach of that contract and there's damages. Your Honor, when I draft complaints, I track the Michigan jury instructions, civil jury instructions. I also utilize ICL's civil causes of action form book. And this complaint tracks the elements and it makes the factual allegations. The defendants may not agree with that. They may claim they have defenses or some of these things aren't true. But as the court knows, when deciding a motion based on 2.116 C8, the court must accept all factual allegations in the opposing party's pleadings as true. And the motion can only be granted when a claim is so clearly unenforceable that no factual development could possibly justify recovery. So I addressed the court's in the defendant's statement with respect to the requirement to attach a contract or a written instrument. That is simply not true, so long as we state the elements of a breach of contract and we provide factual support for those claims, which we've done. I want to turn to fraud. Fraud must be pled with particularity, according to MCR 2.112B1. And we submit, Your Honor, that it was. And these factual allegations have to be considered true, but we allege that there were material misrepresentations, that defendants intentionally made false representations of material fact, both verbally and via email to plaintiff, regarding the services, specifically the accounting and bookkeeping services that they were performing, including but not limited to reporting and payment of plaintiff's sales, withholding and unemployment taxes between 2021 and 2024. We go on to allege that they intentionally made these false representations of material fact when they submitted invoices for those accounting services. And going on to paragraph 27 of the complaint, that they were false when they were made because the defendants knew that they didn't do those things. They never filed those things. And so, Your Honor, the complaint tracks not only the elements of each claim, but it provides factual support for each claim. I guess I'll conclude with this, and I'm happy to go through the complaint with as much detail as the court would like, but plaintiff's complaint contains specific factual allegations that reasonably inform the defendants of the nature of plaintiff's claims and provides factual basis and support for the element of plaintiff's claims. That's what's required by MCR 2.111B1. The factual allegations must just reasonably inform the defendants of the nature of plaintiff's claims and provide them with a factual basis. I just find it disingenuous that the defendants are now, in lieu of filing an answer, have said that they don't understand the basis of our claims. And I attached Exhibit 1 to the motion, and I acknowledge that evidence is not to be considered by the court when responding to a C8 motion. But it just shows the insincerity of the motion when they sit there and say, we don't understand, we can't defend this because we don't understand the allegations against us. When the email, she admits what she did was wrong. She admits she didn't file and pay these payroll taxes. And so it's not intended to provide support for a C8 motion. That's based on the pleadings, but it just shows the disingenuous nature. Really what I would say is, a waste of time with this motion and defending this motion. I've asked for my costs pursuant to MCR 1.109E. Those can be granted pursuant to a motion by a party or at the court's own initiative. I'll rest on that, Your Honor. I'm happy to be answering any questions you may have.
She addressed the Consumer Protection Act and says it doesn't apply to commercial services. Can you address that?
Yeah, procedurally, that wasn't raised in the motion. That was not addressed in our response. It was raised for the first time in their reply. I would tend to agree with that analysis after looking at that and looking at their reply. I would withdraw count 5 of the complaint, as I do agree. The plaintiff is a person as defined by the statute, but these were bookkeeping and tax services for a commercial entity, and so therefore I would agree with that argument, Your Honor.
Okay, thank you, appreciate that. Your response?
Thank you, Your Honor. As far as the request for sanctions, Your Honor, I think by virtue of the fact that one of the counts was improper here and did not state a claim upon which relief could be granted the Michigan Consumer Protection Act, by virtue of that alone, I think plaintiff's request for sanctions or request for fees should be denied, as our motion was proper because the Michigan Consumer Protection Act does not apply here. Additionally, plaintiff's counsel brought up that the allegations are from 2021 to 2024. This brings up significant statute of limitations defenses that we need to understand when the alleged fraud, when the alleged negligence occurred, because the statute of limitations may be a defense here. If it happened in 2021, more than 3 years have passed, and therefore it would be barred by the statute of limitations. If it happened in 2024, 2023, that's different. But we need to understand when the alleged negligence occurred, when the alleged breach of contract occurred, who this contract was with, and when it was entered into. Was it entered into in 2021, and this has been a continuing service that's been provided, or did it occur in just 2023 or 2024?
Well, are you denying there's a contract at all? Obviously, there was some kind of meeting of the minds because work was done by your client, correct?
That's correct, Your Honor,
Okay,
and that's
so-
what's alleged in the pleading, and so that's accepted as fact.
Okay, if that's accepted as fact, one of the things that you assert is that there must be a written contract attached. Well, that belies the fact that oftentimes, too often, there are oral contracts that people abide by. So whether or not this is oral or written, we can't attach something that isn't available or known, but it does appear that both parties acted as if there was a contract. I do agree time frame is important, but there's a contract here based on the offer of proof, if you want to call it that, from what both of you have said. So I'm assuming there's a contract, attached or not, the actions speak to it, and so the language of a written contract is not needed because both your pleadings speak to it.
Well, Your Honor, I think what our problem is that the allegations for the breach of contract claim, that's what we're focusing on right now. But for the breach of contract claim, it did not allege that it was a written contract. It did not allege who had entered the contract. It simply says all 3 defendants were parties to this contract, which would be highly irregular for an employee, the owner, and the business to all be parties to an oral contract. That just simply is not what we've seen in contract. A contract is offer, acceptance, and consideration. And so if it is an oral contract, that needs to be appropriately pled in the complaint to say an oral contract and to say what was the offer, acceptance, consideration to make up the essential elements of an oral contract.
Okay, got it. Here's what we're gonna do.
Yes, Your Honor.
He's withdrawn count 5 of the Michigan Consumer Protection Act. Both sides, your costs, sanctions, whatever awards are preserved. This case is going to move forward. I'm going to have plaintiff amend. I'm going to allow amending the complaint to remove count 5, but also to plead with specificity as to who, what, when, where, in terms of are the actions of all 3 and the specific dates, so we can see which, if any, are outside the statute of limitations, and we're only going to deal with those within the statute of limitations, unless you want really to come back in front of me on another motion for summary. I'm sure that you can break out those dates. And I think that's really the issue, is they want to narrow the issues so we don't have to do work that's outside the scope of the statute of limitations. Can we do that?
We can do that, Your Honor. I'm not so sure at this point We know specifically what was done when and what years. I will say this, for professional malpractice for accounting, it's 2 years after the termination of services, after the termination of the relationship, which occurred in 2024. So we're not up against the statute of limitations issue. We're certainly not up against the statute of limitations issue with breach of contract. So my allegation is these things, the malpractice occurred between 2021 and 2024, and the service is terminated in 2024. So, I mean, I can amend and try to do better, but the allegation is the malpractice occurred between 21 to 2024 and services terminated in 2024. I don't know how much more specific I can get.
So,
Particular time.
wait a minute, so you said it's 2 years for accountants, right?
Yes, from the termination of services. So
And
it
the
was in
termination of
August-
services was 24.
August of 2024.
So it really would be sometime, I guess it could be 20, depending on when, 21, end of 21. No, it'd have to be 20, between 22 and 24, wouldn't it?
No, it's from, Your Honor, it's from the time that the services terminated, the relationship terminated. So same with attorney, client.
Okay.
So if I represent a client, for example,
So-
a plaintiff in this matter, it's when the services terminate.
Okay,
At that point, when the relationship, let's put it this way, when the relationship, the attorney-client relationship, or in this case, the accountant customer relationship terminates, that's when the 2-year statute of limitations runs.
so the 2-year statute is within the 21-24 timeframe.
Your Honor.
Correct. The statute of limitations would expire in August of 2026, which is the 2-year anniversary of the termination of services, which occurred in August of 2024 when this was all uncovered.
Your Honor, if I may. I think what opposing counsel is talking about is when a contract and a relationship has been ongoing. That relationship can break if the services pause or if a new contract is entered into. And that is why it is so important to understand the contract and understand the timing of these services.
So
because
I'm sorry to interrupt, are you disputing the between 21 and 24 and that it ended in August of 2024?
I'm saying we don't know based on the pleadings.
And Your Honor, these are factual
Well-
disputes. The allegation
Okay.
has to be accepted as true, which is from 2021 to 2024.
Sir, here's what you're gonna do. You're gonna amend it in regard to those people, so we figure out who did what. If you can make the dates clearer, then you can make them clearer. If not, then we're gonna have some discovery and you all can bring your motions for directed verdict again, or to limit the pleadings or quash or whatever you want, but you're just gonna amend and fix up whatever you've heard here today. If you want to copy the transcript, go ahead. But clearly, I think she's asking for the 3 people or however many were involved. If there's no contract, you can say that this was based on an oral contract. A written one has not been found, but that's something you'll demand in discovery, or however you want to word it. I don't really care, but I am deeming that an oral contract is a valid contract. At this point, we don't know.
Yes,
I mean, clearly, the elements of contract were met, and we don't have a written one, but that's not unusual in our world. That's what keeps lawyers employed. So,
Thank you, Your Honor.
all right, so how long is it gonna take you to draft this?
How about 14 days?
I'll give you 28.
Okay. Thank you, Your Honor.
I won't be looking at it in 14 days. Okay, and because I suspect that dealing with 3 people and all of that, the coordination with the holidays and everything. And if you need an extension, let me know, but let's just start with 28. Is that
we're
right for
happy to
everybody?
grant an extension if it.
Okay, so she'll grant me an extension.
Okay.
All right, because there's holidays and I don't know, so
Okay,
if you need an extension, that's fine. And then just, we'll go from there.
okay.
Thank you.
We'll sub- I'll
submit the
draft an
order?
order and I'll send it to
Perfect.
opposing counsel.
Thank you.
Thank you, Your Honor.
That's all for this record.
The whole first deck is the newest. So,
Yes.
no, Just the one that's,
This,
yeah, minor, but there's three in there. There's the objections, the response, and the proposal.
this is docket 25-925 CK, Khalid Zakara, Marl Zakara, is it Zachariah? Yeah. Versus Michigan Montessori International. Counsel, your appearances for the record.
Your Honor, I'm Dr. Zachariah, and this is my wife, Maral.
Please raise your right hands. Do you swear or affirm that the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do, Your Honor.
Thank you. You both have a seat, counsel.
Good afternoon, Your Honor. May it please the court, Brian McGorst, Punch County, appearing on behalf of the defendant.
Thank you. And sir, we have plaintiff has written objections to the updated order. Why, sir? Where is this?
Your Honor, obviously, the reason I filed objections to the order is because it didn't comport with your ruling at all. A day after you ruled, defendants submitted a notice of presentment of order under the 7-day rule.
Yes, he's
just one-
entitled to do that.
Yes, I understand, but when we left the courtroom last time, Your Honor, you had explicitly indicated that there was one pending issue regarding who is responsible for compiling the costs of those academic records. And I had brought to the court's attention that this was something that had not been raised in the motion for summary disposition, but only during the hearing, and you ruled on that kind of on the spot. And when I brought it up last time, you said you both need to file supplements. And rather than filing a supplement and then an order that deals with that issue, he quickly jumped in and filed this order. This is not the last issue that pending that deals with this case. This case is not closed until we deal with this issue. I expected him to file a supplement so that I can respond to it, since he was the one who
So
filed
those
it.
cases pretty much over. I've already made my rulings. Have a seat. Sir, what has happened here?
Judge, well, my associate Kelsey Hall was here for the last hearing. You granted our motion in total, the motion that we filed in lieu of the answer, and there were a couple things that you said. First of all, you said that it was frivolous and that we were entitled to costs and attorney fees, okay, and we submitted an order on that. You also said in an effort to try to settle this issue that we had to produce the academic records, okay? And that was part of your last order, and we have the records. We're waiting for this order to be settled. And then there was going to be a hearing on the cost if necessary. And other than that, the case was closed.
Yeah.
We submitted an order. In fact, my associate wrote down, she took your notes right from the order that you gave her back. And all we did was submit exactly what you said. This is what we've been dealing with for the last 2.5 years.
Yeah.
He objects to everything.
I know.
I mean, we're on our 5th case, Judge. I would just only point out, like, he wants language in there to indicate that the court arbitrarily granted on grounds of res judicata.
That's denied. If you want to see if I'm arbitrary, go to the Court of Appeals. We're done here, sir. The order is the order. It comports with what I said. They've complied with providing your child's information. I don't know what more you want. You want some very picky language that is not appropriate, not accurate from where I sit, and you're wasting the court's time and everybody else's time. So the order that was drafted is going to stand. I didn't sign that, didn't I?
No, you didn't sign it. Yeah, it was submitted under the 7th day rule. Should be there, Your Honor.
Your Honor.
Sir, what language specifically are you objecting to? Because I'm not going to put things that I didn't say.
Your Honor, I don't want you to put things that you didn't say. All I want is to have in the order things that you did say. His idea of a good reason is misleading the court. Last week, they admitted to the fact that they had been misleading the court on the grounds of res judicata by saying that this issue was up in the Court of Appeals. And then they said, oh, no, it's not. So this issue, so I have to wonder, why was res judicata granted? I took the time to file a response to their motion for summary disposition, and I cited all the case law that shows that res judicata does not apply. And it doesn't matter if I brought 10 cases to this court, as long as they arise out of a different transaction or occurrence, it does not matter. I have the right to do that. And he's trying to say, you don't have the right to do that. And the law says the burden is on them, the person who brings res judicata, to prove that it arose out of the same transaction or occurrence. And all he does is he repeats that it arose out of the same transaction or occurrence without proving it. So I am left to wonder here, why did res judicata apply? That's my simple question. And I think I deserve to know, given that I've applied a lot of time researching the issues and writing my response and showing the court the legal authorities that prove my point. I don't understand how the court can say res judicata applies, but I'm not going to offer a reason after the defendants admitted that the reason that the court relied on in the hearing for the motion for summary disposition was completely made up, and that they had been misleading the court. So I'm left with nothing. You know, if the court wants to leave me with nothing, I'm fine. It's the court that decides. I have no issue, but I feel I'm entitled to know why res judicata applies. That was my only issue. Okay, and then he says, and last time you were very explicit, Your Honor, the Court of Appeals returned its opinion, and it explicitly said that we are reversing sanctions that were issued in a prior case. And you said, okay, no sanctions here. Those were your words. Now he comes back and he writes an order where he says, oh, this is a frivolous case. Well, if it's a frivolous case, then you have to assign sanctions. You can't say it's a frivolous case. You ruled last time that it was, you're offering them costs because they were the prevailing party.
That's right. Sir, I'm offering them costs because they were the
Yes,
prevailing
thank you.
party. I got rid of these sanctions.
Thank you.
And res judicata means it's been decided. This case has been decided several times, several ways. You are not happy. This should not come in front of me or anybody else again. What this case was about is you wanted your children's school records. They've been provided, they will be provided. End of story. Why are we coming here again and again for the same issues?
Your Honor, he wrote in his order.
I don't care what he wrote. Did you come here for your children's school records? The answer is yes, correct?
Yes.
Okay. Did you provide the school records?
They're compiled, Judge. We're ready to turn it over.
Great. When are you gonna turn them over?
Within 14 days of the order is what.
Great. I just signed the order.
Okay.
This closes the case. We are done except for costs. I will get rid of the sanctions. You want a Smith versus Query hearing, that's fine. Turn over the records, whatever format you have, give it to them and let's be done. This is a waste of both of your time. Sir, spend time with your family, not in court. Sir, you spend time with your school district and stay away out of my court too. I want some real issues. These have been decided multiple times. I keep repeating myself. I suspect the Court of Appeals will be repeating themselves. We are done. That's all for the record. Thank you. my way to jail. Please remove yourself from my courtroom. Now,
Thank you, Judge.
thank you.